This is an episode of Scott Talks Law, and in this episode, we are going to talk about the employment relationship under individual employment law. So, the most important question under employment law is who is an employee? And the answer to this question is fundamental in the understanding of labor law, because we have instances where people just work for others, they are not recognized as employee. But they are just doing the work, and this usually occurs because of the host of legal and financial obligations that are associated with the recognition of someone as an employee. So we have got some implications that confirms that there exists that employer-employee relationship, and these are implications like pay as you earn contributions, insurance of paying of personal national insurance contributions to the employees, insurance of injury and work services to the employee, payment of redundant employees, pension services, vicarious liability, provision of a safe working environment by the employer. Those are just some of the circumstances that confirm or the implications of employer-employee relationship, that relationship actually exists. So the employment relationship doesn't always work as other working relationship, because other working relationship there are not those legal and financial obligations as opposed to the employment relationship. So Section 2 of the Employment Act is the one that defines an employee as a person who receives wages and salaries for a particular work, and the obligations of an employee in an employment relationship are set out by statute, the statute or common law, which is just implements the statute, and other circumstances where they exist just a principal and independent contractor. The obligations or the certain tasks to be performed are set out by court. So doing just ordinary service, when you just work for someone, it doesn't always mean that you are his employee, or when you just receive orders and instructions from someone, does not always mean that you are his employee or that employment relationship exists. Does not always happen in all circumstances. So we're going also to look at those three tests: the control test, the multi-factor test, and the integration test, that confirms that if truly there exists an employment relationship. Like under the control test, according to this test, they say that a person is an employee if he receives control from someone. Like if person A employs person B, then person B will be controlled by person A, and this person will do everything that person A tells him. So if this person receives this is the instructions from person A, then the person B is deemed to be an employee to person A, and that control is there where an employer controls the employee. And if person B receives those instructions but does not do according to what he has been told, he just performs the work according to his own skills, ability, and knowledge, then he is deemed to be an independent contractor and not an employee to the employer. So we're going also to look at other tests like the integration test, whereby the work must be integrated for there to be an employment relationship, and the multi-factor test, whereby it is viewed in the eyes of an ordinary person that there indeed exists an employment relationship. So just stay tuned, subscribe to First Legal channel. We are going to go deeply into and talk about this entire employment relationship. Have a nice day.